17th July 2026, and this is the first presentation of this live premiere. Eminent domain for AI infrastructure, the governance gap explained today. Imagine waking up to a letter that says, "We are acquiring your property not for a bridge, not for a school, for an electricity transmission corridor, one that feeds an AI data center. You have 30 days. Tonight's puzzle for you. What body of international law specifically protects you from this? Is it the International Covenant on Civil and Political Rights? The UN Guiding Principles on Business and Human Rights? A bilateral investment treaty? A regional human rights framework?" Hold that answer, because by the end of this presentation, we resolve it, and the answer may not be what you expect. But before I say another word, I want your answer. Drop it in the comments right now. Which framework do you think protects that family? Getting it wrong tonight is how you get it right for the rest of years. Good evening and welcome to the AI Law Daily. I'm your host, Nupur Mitra, a techno-legal analyst and a registered lawyer, and this is a daily live conversation at the intersection of artificial intelligence, international law, and the governance gaps that neither has yet mapped for the other. Every evening at 8 o'clock Central, we open with a puzzle. We build the architecture of an argument together, and we close with a resolution. Tonight is our very first episode, and we are beginning not with theory, but with a story that is unfolding right now in real time with real families inside a legal vacuum that AI governance has never addressed. In the state of Georgia, a utility company has invoked the legal doctrine of eminent domain. This is the power granted by the state to compulsorily acquire private property for public use in exchange for compensation. Up to 30 families, 35 miles of transmission corridor, built specifically to deliver electricity to AI data centers. One homeowner described it simply as, "It is theft." Now, that statement is not a legal argument, but it is a deeply human response to a deeply structural problem. And that is precisely what the AI Law Daily exists to analyze here. Because here is the question this situation raises at the level of international governance. When a state's domestic legal doctrine, eminent domain, compulsory acquisition, expropriation is mobilized in direct service of a private AI infrastructure agenda, does that mobilization create new accountability obligations under international law? This is not a domestic property law question. It is an AI governance question, and it sits inside a gap no existing framework was designed to fill. Let us build the legal architecture here. At the international level, the right to adequate housing is protected under Article 11 of the International Covenant on Economic, Social and Cultural Rights. The UN Committee has clarified in General Comment 7 that forced evictions, even those accompanied by compensation, must meet a threshold of procedural fairness, genuine consultation, and genuine consideration of alternatives. The UN Guiding Principles on Business and Human Rights, the Ruggie framework, place obligations on both states and corporations to respect human rights across their operations, including infrastructure operations. These frameworks exist. They're not without force. Here is the gap. Not one of these instruments specifically address AI infrastructure as a category of state action. The Ruggie principles were finalized in 2011. The ICESCR dates to 1966. General Comment 7 was adopted in 1997. Not one contemplated a scenario in which a state exercises sovereign compulsory acquisition powers specifically and directly to enable the physical infrastructure of an artificial intelligence ecosystem owned by private corporations. This is what we understand as an AI accountability gap, a scenario that existing law addresses only partially, by analogy, and without the specificity that modern AI infrastructure demands. And it matters enormously because when a framework is vague, it is litigated. And when it is litigated, the weaker party, the displaced family, the affected community, bears the full burden of establishing that this framework even applies to them. That is not a legal accident. That is a governance design failure. Quick gut check before I resolve this. I want to see where this room stands. Should a family lose their home so a private company can power an AI data center? You must comment 1 if you think there should be a binding international standard that stops this. And you should comment 2 if you think domestic law is already enough. One word, put it down now. So, let us return to your puzzle. What body of international law specifically protects you when your home is acquired to power an AI data center? The honest answer is this. Existing frameworks offer partial protection. Article 11 of the ICESCR, General Comment 7, the Ruggie principles, regional instruments, depending on your jurisdiction. But no instrument offers AI-specific protection. No framework uses the words AI infrastructure. No treaty maps the accountability chain that runs from a data center operator through a utility company through a state's eminent domain apparatus to the family holding a 30-day notice. That chain is operational. It displaced 30 families last month. The law has not caught up. That is your answer tonight. And that gap between what AI infrastructure demands and what international law currently provides is the subject of this entire series. Tonight's takeaway is this. The absence of AI-specific language in foundational international instruments is not a technicality. It is a governance architecture problem. It means the people most directly affected, the individuals living at the edge of a 35-mile corridor, must argue their case by analogy in frameworks that did not anticipate their situation. Tomorrow evening, Live 2 premiere, we examine the world's first legally binding international AI treaty. 46 nations signed it, and we ask, does it actually bind a single AI company? Same time, 8 o'clock Central in the evening, tomorrow again. Be here. If tonight added precision to how you think, do these 3 things. Follow me on my LinkedIn, Substack, Instagram. Subscribe at the AI Law, this YouTube channel here, and subscribe to my newsletter on thoughtleadinnovate.com so that all my works land in your inbox. And the moment tomorrow's puzzle goes up, drop your answer in the comments. This is the AI Law Daily Premiere series from this channel, the AI Law, Global Security, AI Risks and Liability, governed by evidence, guided by law. Good night.